Is there a way to avoid a court confirmation sale of a probate home once an heir has objected? We get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Mohr, Realtor, Masters Club Life member, and Certified Probate and Trust Specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary, as well as I'm a licensed California real estate broker, and I'm also a registered and bonded legal document assistant specializing in probate and trust administration work.
Now go ahead and like and subscribe, and if you've got a house to sell, we can help you avoid the cost and headache of probate and trust administration. Those services come with the listing at a phenomenal discount with no upfront fees, saving families thousands in costs. We can even help with the petition to determine succession, the primary residence process. Our contact info is in the About section. Don't wait, reach out today. So you have a house in probate, it's for sale, got an offer, and an heir objected. Now it needs to go to a court confirmation hearing. Nobody wants to go through one of those. We've done several. I was just at one. It's such a long process, but can you avoid it? The short answer is yes, and I'm just going to go through a few quick notes here on some suggested steps to resolve that situation. Communicate with the heir and beneficiary who has objected. Big key right there. Try to find out why he or she has objected. Discuss the reason for the objection and see if it can be resolved. And if it can be resolved, then the objector can withdraw his or her objection in writing and filed with the court. Then the sale can proceed as if the objection never occurred. Those are some good bullet points right there, because sometimes it's something really, really, really silly.
Yeah, sometimes it's very minor and a little discussion can resolve it.
Now, Bill, what if the objector will not withdraw their objection, or whether the reason is valid or not?
Yeah, that's a problem. We've seen situations like I'm going to describe right now where, you know, oftentimes an heir or a family member is living in the probate home that everybody else wants to be sold, and the person, the heir, the family member living in the home gives these types of reasons as to why they don't want the home sold. Mom said that the house would be mine when she passed away, after she passed away. But there's nothing in writing to state that. There's no will, there's nothing in writing. So all you've got is the heir who's living there telling you that mom said the house should be his or hers. The other one I've seen is we'll get someone who'll say, look, I took care of dad for 3 years up until he passed away, and the house should go to me. The other one that we get often is an heir will say, I have no place to go to live, so I should get the house. Unfortunately, these are not valid reasons. At least they're not going to be valid reasons in front of a court or a judge when you try to convince them that that's why the house should go to you as an heir. What you have to understand is that even though a particular family member or heir wants the house for himself or herself, you can't stop the other heirs from receiving their deserved inheritance in that home. You can't stop that. Not for the reasons I just talked about. And what's going to happen is if the objecting heir will not withdraw their objection, you're going to go to a court confirmation hearing, and the judge is going to approve the sale. It's going to go through. But before that happens, who knows? The heirs who's objecting, as well as the heirs who want to get the house sold, will probably have to hire attorneys and end up in the probate court fighting. And this is going to cost everybody money and time, and the end result is going to be the same. The house will be sold, and it'll be sold. The proceeds will be divided among the heirs, less all those attorney's fees that have been paid out, really fighting for probably nothing. So, you know, if you're an heir who's going to object to a sale of a home, you better have a really, really good reason that the court or the judge is going to believe is a valid reason. Because if you don't, you're going to spend a lot of time and probably a lot of money for nothing. The house will be sold at a court confirmation sale.
Yeah, we've seen all those objections before, or at least verbalized, even if they weren't official objections.
Yep.
And when it actually gets to that court process, it's a losing battle. It can be costly.
Yeah, just as a little quick example, we had a property in Oakland, California a number of years ago where this exact situation, and the heir wouldn't leave and stalled things for quite a while, wanted the house for himself, and ended up, the house eventually was sold through a court confirmation process. But it was sold at, I want to say 60, 70, maybe even $80,000 less than what we had an original offer for.
Yeah, we had exited the situation and it went to a different broker.
Yeah.
The first buyer that we procured, which was a great offer, went away. It was many, many months later that the house ended up selling under a different real estate broker for tens of thousands of dollars less.
They lost a lot of money.
Plus any sort of holding costs, taxes, all of that, and their legal fees went way up. Unfortunately, it probably cost that estate close to 6 figures.
Yeah.
Because of that one decision.
Yeah. But it happens. But as Brendan was saying earlier in the video, the best way is to open the lines of communication between the family and the heir who's living in the home, and try to resolve the situation. And hopefully you can get that heir to withdraw their objection and then move on with the sale without a loss of a lot of time and money.
And if you have any questions about this process, please reach out. Love to talk to you.